that the information today is helpful in follow-up to the webinar that we provided a few weeks ago. It seems like it's been longer than that, and I know that these are pretty difficult and challenging times for everyone. So before we get started, just on behalf of Morris Manning, we just all wanted to say that, you know, we hope that you and your families and friends are staying healthy and safe during this time. And while we're here to talk about some of the nuances and technical aspects of the law, you know, first and foremost, this is a human issue and this is a health issue. And, you know, we acknowledge that, and we're partners with you in solving some of these issues. And we hope that the information that we provide here today will be helpful to you and to your friends and to your clients and customers in navigating what are particularly challenging and unique times. So with that, we'll go ahead and get started. Our webinar today is going to be a little bit different. We're going to be going through frequently asked questions. So we thought that probably the best way to get you, you know, what the guidance that we're talking to clients about every single day is to go through what are some of our most frequently asked questions from clients about employment and benefits issues right now related to COVID. And so we'll cover a number of topics, going through some recent legislation, talking about some employment restructuring and employment-based changes, layoffs, furloughs, salary reductions, and hour reductions. We'll talk about some of the benefit plan changes that companies are contemplating. We'll talk about recent legislation and how that impacts benefit plans and how that applies to some tax extensions, and wrap it up with some shelter-in-place orders. As Amelia mentioned, we will have a Q&A at the end, so we'll reserve time and we'll stay after if needed to answer questions. Please feel free to type your questions in the Q&A box. If you have any questions about that, please reach out to Amelia, who will assist you with that. And with this, we'll turn it over to Meredith Kayafa, who's going to launch us right into our first question about reduced hours and laid off employees.
Hi, everyone. Since we spoke to you last, there have been quite a few developments with the FFCRA. We've gotten some guidance from the government in terms of regulations from the Department of Labor. And the Department of Labor has also continued to update a very comprehensive set of FAQs on its website. So I encourage everybody out there to review the Department of Labor's website. The Q&A section especially is being constantly updated, even without announcement. If you check it from day to day, sometimes you'll find that the DOL has updated some of their guidance. So that's always a good resource if you have questions. And these are some of the main questions that we have been receiving about the FFCRA and the associated regulations. And the first question has to do with the circumstance of what if you have reduced hours or laid off employees? How do you then provide this leave to employees in that circumstance? And it's good with this issue to think of the issue of eligibility as distinct from usability. So if an employee is completely laid off, meaning the employment relationship has terminated, they're not performing any work from you, they are not eligible for leave under this law. You have no obligation to provide it to them. And that's true regardless of whether the layoff was due to a federal, state, or local directive related to COVID-19. However, if the employee is still employed by you and they're still working to some degree on a reduced schedule, you are required to provide that employee with paid leave under the FFCRA. They are eligible if they otherwise qualify based on one of the enumerated qualifying reasons. The key here, though, is that even though they are eligible, they cannot use the leave for hours that they are no longer scheduled to work for. Leave is only usable for the time that they otherwise would be needed to work. So if you have an employee who you have reduced their hours, say they went from a full-time 40-hour schedule to a part-time 20-hour schedule, they're eligible to take the full 80 hours of paid sick leave, but they can only use it for the half time that they are currently scheduled to work. They can't use this paid sick leave or extended family medical leave to top up their schedule so that they get a full paycheck. And the amount of the leave that they're entitled to take is computed based on their average work schedule before it was reduced. And then the other thing here is poster requirements. Hopefully you've all posted the required notice from the Department of Labor about the FFCRA. There's been some guidance on that saying that because most workforces are remote now, you can email it to your remote workers, or you can post it at some sort of centrally accessible database like your company portal. And also, once you're able to go back into your building, post it in the normal area. There also with the poster was a change. I think it was right before the deadline date of April 1st. So if you were super on top of things and got your poster ready in the days leading up to April 1st, check back and make sure you have the most recent draft of the poster. It was a small change, but it's good to make sure you have the most updated version. The other thing to keep in mind with poster requirements is all covered employers are required to post the notice. That means if you're a company that has fewer than 500 employees, even if you believe some employees might be exempt from this law because of the healthcare provider exemption or the small company exemption, which we'll discuss later, you still do have to provide the notice, even if you think all of your employees would be exempt. The next slide is an example. There's no question with this example, but this is intended to address the question of how do the two components of this law work together, the paid sick leave and the extended family medical leave sections. So in this example, if you have a full-time eligible employee who is unable to work or telework due to the closure of a school or place of childcare, this employee is entitled to up to 80 hours, which is 10 days of paid sick leave, and up to 12 weeks of job-protected EFMLA leave. The first 10 days of that will be covered as federal paid sick leave at the full rate, with the cap of no more than $200 a day and $2,000 in the aggregate per employee. Though the employee could elect, you can't require the employee to do this, but the employee could elect to use other sick pay, vacation, or PTO to supplement that capped amount. The remaining 10 weeks would be paid by the employer at the 2/3 of their regular rate of pay, up to a maximum entitlement of $200 a day and $10,000 in the aggregate. So basically in this situation, if the qualifying reason is a school closure and the employee being unable to work or telework, they get 12 total weeks. The first 2 weeks is covered by paid sick leave, and the subsequent 10 weeks, up to a total of 12, is covered by EFMLA, all of the amounts subject to the relevant caps. The next slide poses the question of, can employees take intermittent leave under the FFCRA? This is a complicated issue, and the answer essentially is yes, under certain conditions. The first condition being that only if the employer and the employee reach an agreement about what a suitable arrangement is. The DOL has been very clear that absent an agreement, no leave under the FFCRA may be taken intermittently. The agreement doesn't have to be written, but there has to be a clear and mutual understanding between the parties of exactly what the schedule will be for the intermittent leave and the increments of time during which intermittent leave can be taken. So for example, maybe you reach an agreement with one of your employees who says that they can work from home, but not their full normal schedule because they have to take care of their child due to a school closure. Maybe they can only work 3 days a week from home instead of all 5 days a week. You can reach an agreement with them that they can take the expanded FMLA leave to take care of their child, for instance, on Monday, Wednesdays, and Fridays, but work either remotely or at the work site on Tuesdays and Thursdays. And when you reach an agreement like this, keep in mind that only the amount of leave actually taken can be counted towards the employee's leave entitlements. And the Department of Labor is encouraging employers and employees to collaborate and be flexible to try to make this leave work so that employees don't have to leave their jobs. The second condition that applies with the situation of intermittent leave is that employees who continue to report to an office or a work site can only take intermittent leave if there's a minimal risk that the employee is going to spread COVID-19 to other employees at the work site. If they are working from home, that's not a concern. You can structure intermittent leave however works for you and the employee. But if there's someone who's going to be coming into your office, this is kind of a common sense thing. If the reason that they want to take the leave is because they are caring for someone who's sick or they themselves have been exposed or sick, that is a situation where you should not allow them to take intermittent leave so that they would be essentially going back and forth between a potentially quarantined environment or the office. The other thing to keep in mind with intermittent leave is this is one of the sort of hot issues that certain members of Congress have taken issue with in terms of the regulations that have come from the Department of Labor. There was a letter written by a group of Congress people recently challenging this rule by the DOL, which in practical terms means that an employer, if an agreement can't be reached, can refuse to provide this leave intermittently. They say that that is not sufficiently in line with the goals of the law, and there should be more legal requirements that employees are, or that employers have to provide this leave intermittently. No word yet on whether the Department of Labor will be changing that rule, but that's something to watch out for. The next question is, how do the exemptions operate? Under the FFCRA, there are two possible exemptions. The first one is for small companies, which means fewer than 50 employees. And the second one is for categories of employees who are defined as healthcare providers or emergency responders. The Department of Labor has provided some additional guidance on how each of these exemptions operate, and they've emphasized that employers should be judicious when using these exemptions. The exemptions really should be viewed as a balancing act between protecting the employees while at the same time making sure that companies can still provide essential and necessary services. The first exemption is the small business exemption, which, as I stated, if you have fewer than 50 employees, generally you're going to be exempt from providing this leave due to a school or place of care closure and child care provider inability for COVID-19 related reasons, if doing so would jeopardize the viability of the small business as a going concern. And there's been a lot of questions here about how do I apply for the small business exemption? How do I make sure that I'm exempt? The answer from the Department of Labor is that you don't have to apply for the exemption right now. Rather, you just want to make sure that you document it internally, that you can show that you went through the analysis to establish that this actually would jeopardize the viability of your company as a going concern. And then down the road, if that decision is called into question, you've got all the documentation showing that you went through the proper analysis. The other thing to keep in mind with the small business exemption is that this is a narrow exemption. Small businesses are only exempt from providing the leave related to school closures and childcare unavailability. Small businesses are not exempt from providing leave for any of the other types of permissible requests under the FFCRA. So for example, if you have an employee who has been advised by a healthcare provider to self-quarantine related to COVID-19, or if an employee requests leave to care for an individual who is self-quarantining, the small business must still provide the appropriate paid leave, and there is no exemption for that type of request. The next exemption relates to employees who are healthcare providers. An important key with this one is that the exemption applies to the employee, not the company as a whole. The healthcare provider refers to the status of the employee. So a company, even if you believe that your entire workforce is made up of healthcare providers, technically you still have to consider each leave request as it comes in and make sure that the particular employee requesting leave properly fits this definition. And the definition of healthcare provider has been expanded significantly from the way that it's used in the original FMLA. When you're talking about an employee who has requested leave under the FFCRA, a healthcare provider is anyone who works at any doctor's office, hospital, healthcare center, clinic, post-secondary educational institution offering healthcare instruction, medical school, local health department or agency, nursing facility, retirement facility, nursing home home healthcare provider, medical testing laboratory, or pharmacy. So that is an extremely broad range of jobs. And it also includes anyone who works for an entity who contracts with any of the above institutions to provide services or to maintain the operation of the facility. Or also someone who works for a company that provides medical services or produces medical products. This is another area where we've seen some pushback from members of Congress. They believe that this definition is way too broad. They've argued that it covers anyone who conceivably does a job that's somewhat related to the healthcare industry. So the guidance from the DOL, while this is the definition that we have, is that companies should apply this exemption judiciously and take a look at the person who's requesting the leave and see if it's true that they, A, fit the definition, and B, that you really do need them working and you cannot provide this leave and still be able to run your company properly. And we would recommend in that situation documenting how you made that decision along with any other issues related to the request. The next exemption is an exemption for emergency responders. This again is a very broad definition. I won't read the slide to you, but take a look. It generally includes people with skills or training related to responding to situations that arise with COVID-19. It also includes individuals that the highest official state of a state or territory determines as an emergency responder necessary to the response. But the same rules apply with this definition. Apply judiciously, consider each employee request independently, and document the analysis that you go through if you're going to take the position that a particular employee is exempt. So the next question that has arisen with the FFCRA is, how am I supposed to document this? We all know that under the regular FMLA, there are a whole series of forms and the documentation process is very clear. We don't have the same set of forms yet from the government for FFCRA leave, but the guidance that has been issued is that an employee has to provide a signed statement containing the elements listed on this slide, and that additional documentation may be required depending on the COVID-19 qualifying reason for leave. It's also important to keep this documentation on file for 4 years. So the other types of things that you might need to document depending on the type of leave is the name of the government entity that issued a quarantine or isolation order, the name of a healthcare provider who advised an employee to self-quarantine, and if the request is for expanded FMLA leave due to the closure of a school, the employee has to provide the name of the child being cared for, the name of the school or place of care that was closed, and a statement representing that no other suitable person is available to care for the child during the period of requested leave. And some questions have arisen about, what does suitable person mean? How much does an employee have to provide in order to prove that they've exhausted all possible avenues of childcare? Those are very fact-specific questions that we don't have any guidance for right now, but from the information that we're getting from the Department of Labor, it appears that it is up to the parent, the individual parent, to make the decision about whether or not another suitable person is available to care for their child. And then the company can make a common sense, reasonable judgment about whether that appears to be a truthful statement when they're deciding whether or not to provide that leave. The other thing to keep in mind with documentation is that if you have an employee who's taking the EFMLA for their own serious health condition or to care for a spouse, son, daughter, or parent with a serious health condition, that would also implicate the normal FMLA. So you would want to follow the normal FMLA certification requirements in that situation. And also, failure to provide appropriate notice does not in itself justify denying a request under the EFMLA. Rather, the employer should engage in a process with their employee, point out the deficiency, and give the employee a chance to correct it. The next questions relate to some of the cost issues and the tax credits. So I am going to pose these questions to Scott. Scott, what is this going to cost a company?
Thanks, Meredith. So the maximum potential cost per employee is $15,110. That's a little bit of a misleading statement, though, because there are tax credits that are available to companies who have to pay sick and family paid leave under the FFCRA. So the maximum that you could have to pay out is $15,110 per employee. That would include an employee taking the 2 weeks of the paid sick leave and then the full 10 weeks of the family care related leave, meaning that they are unable to work or telework due to childcare needs because their child's school is closed or their child's daycare is closed due to coronavirus reasons. So that's the max. However, like I mentioned, you are entitled to tax credits to offset these costs. You can take a tax credit for the wages that you pay or are required to pay under the FFCRA. You can take a tax credit for the Medicare portion of payroll taxes. These wages are not subject to the Social Security portion of payroll taxes for the employer side. So they are treated for as Social Security and Medicare wages to the employee based on current guidance. For the employer, they're not subject to the 6.2 Social Security tax. They are subject to the 1.45% Medicare tax, but the employer is entitled to a potential credit for that. So you get wages, the 1.45% Medicare tax, and then employer costs of providing health insurance to employees during that time. It's all subject to the same per day limitations that the FFCRA applies. So the tax credit for all those things, for wages, for the 1.45% Medicare, and the qualified health care expenses would all be subject to the same $511 per day for sick leave and $200 per day for family leave.
Thanks, Scott. And that sort of leads us into the next question, which is how do employers claim those tax credits?
Yeah, one concern that a lot of employers had when these rules first came out is even though they're entitled to a tax credit, they might have to wait until the next calendar quarter to be able to claim it. The IRS and related agencies have put out guidance that suggests and provides a procedure for claiming the credit early. So what you can do is as you're withholding payroll taxes and federal income taxes from employees' paychecks, instead of remitting that to the IRS like you normally would do, if you're paying qualified wages under the FFCRA that would be entitled to a tax deduction or tax refund, you could just withhold and hold back those payroll tax withholdings and not remit them to the IRS and effectively take advantage of the tax credits in a current period. You'll report it on a 941, on your next 941, but you could actually use that money now. You can use up to 100% of your payroll tax withholdings that you collected from individuals' paychecks. And then if you run out of that, you can use federal income tax withholdings as well. And if you run out of all payroll tax and all federal income tax withholdings, then you can apply to the IRS for an emergency payment of the estimated refund that you would receive in the next calendar quarter. So there are ways for you to take advantage of these tax credits in the current quarter.
Great, thank you, Scott. And with that, I will turn you over to my colleague, Eleanor Stone, to talk about some issues related to layoffs.
Thanks, Meredith, and good afternoon to everyone in attendance. For this portion of the webinar, we'd like to discuss the considerations, both costs and otherwise, to think about when implementing workforce modifications. And workforce modifications are an unfortunate reality of today's times, so we wanted to devote some of our time to this important topic. So first, if you're considering laying off employees, what should you know? Well, there could be WARN Act issues under federal and or state mini-WARN laws. As for whether your layoffs will trigger federal and or state mini-WARN laws, be aware of the applicable federal and state-specific thresholds. There could be applicable exceptions to the advance notice requirements. For example, one could argue that COVID-19 is an unforeseen business circumstance, and so you didn't have to provide notice. Recently, the governor of California, of all places, declared that COVID-19 falls under the federal WARN unforeseen business circumstances exception, but you still have to provide notice from the date you knew. So that may cut down on the 60-day notice period, but doesn't mean that you can't provide notice. You don't have to provide notice at all. Also note that we're starting to see our first round of litigation where employees are arguing that employers are using COVID-19 as a false reason for a mass termination in order to give less notice under WARN or no notice at all, when they really had another business reason anyway, before COVID-19 even began. So that's something to keep in mind, and I expect we will see some interesting developments here. And WARN notice requirements are generally inapplicable for temporary layoffs. For federal WARN, this is if the employer can make a good faith showing that the layoff is expected to be temporary, so under 6 months. And there are some state-specific quirks to be careful of. For example, in California, its Mini WARN Act does not make any exceptions for temporary layoffs by covered employees if there's a termination or a mass layoff that meets the threshold requirements. In terms of wage and hour, the employment relationship is severed with both temporary and permanent layoffs. So state-specific final pay obligations, including possible payout of PTO, and separation notice obligations can be triggered. And some states have very specific requirements for both the content and timing of the separation notice obligations. For example, New York requires a very specific separation notice where you have to give it at a certain date and it has to have very specific things inside of it. And then as a best practice, employers should consider offering severance in exchange for a release of claims against the employer. With respect to unemployment, it's triggered by both permanent and temporary layoffs. And there are some, again, state-specific quirks. In Georgia, for example, employers are required to file partial claims online on behalf of their employees for any week during which an employee, full-time or part-time, works less than his or her regular full-time or part-time schedule due to a partial or total company shutdown caused by COVID-19. Of course, this would apply to anyone who's let go temporarily or permanently, but we'll be talking later about furloughs and hours reductions. And then in some other states, Ohio, for example, there's a COVID-specific notice to be provided. The most important takeaway about unemployment is threefold. First, know the obligations in your state as an employer, and if you don't know, seek assistance from counsel. Second, any layoff or shutdown of work, and again, we'll get to furloughs and reductions in hours, will allow your employees to file for unemployment or require you to file on their behalf in a place like Georgia. Third, your employees may not ultimately be eligible for benefits because they may be earning more than the max weekly benefit. The max weekly benefit is an amount set by the state, and it is what the employee is making plus $50. But you should still file on their behalf each week if you're in a state like Georgia where you must do so, and just let the state DOL sort it out. And you should still timely respond to any inquiries from the state DOL, whether you're in Georgia or elsewhere. Otherwise, you're subject to being penalized for the cost of the benefits that the DOL had to pay to the employee on your behalf if it turns out the employee was indeed eligible for benefits.
So I wanted to talk a little bit about some of the benefits issues quickly before we move off layoffs that would come up from the employee benefits side and a layoff. So, think about employee benefits when you are considering whether to furlough or to lay off employees. A layoff is really treated as a termination for purposes of a benefit plan. So the terms of your specific benefit plan will govern. For example, most health and welfare plans will provide that coverage ends at the end of the month in which the employee terminates service. So a layoff employee would be treated no differently. It's a separation from employment. It's a separation from employment for benefit plan purposes, and so coverage will likely end, and there will be a COBRA notification required. Consider your potential severance obligations when weighing whether to lay off employees or to furlough employees, because it actually is a separation from employment. Doing so may trigger certain severance obligations if you have a severance or separation pay plan. And then consider whether your layoff would potentially create a partial plan termination for retirement plan purposes. And my colleague Ryan Gorman will talk more about partial plan terminations in a bit, but generally, if there is a partial plan termination during a year, you would have to vest affected individuals' retirement plan balances. And so if you laid off a significant amount of your population, you might find yourself having to vest their retirement plan accounts. One thing also just to put on your radar, it's a little bit outside the scope here, but just wanted to mention it. A lot of our clients are applying for the payroll protection small business loan that came out with the CARES Act. But layoffs can affect the amount of loan forgiveness. So there is a reduction in the amount of loan forgiveness available to employers who have laid off employees and don't bring those employees back in a certain period of time. So we won't get into the mechanics there, but just go and consider whether your potential layoff would potentially affect your plans for loan forgiveness if this impacts you.
Thanks, Scott. Then in terms of costs of layoffs, this can vary, of course, but for one, there is potential WARN Act liability if WARN was triggered and ample notice was not given. So under the federal WARN Act, the liability to each affected employee equals back pay and benefits to that employee for the period of violation up to 60 days. Then there's a civil penalty up to $500 for each day of the violation. The employer can mitigate this if it goes and gives the money under bullet 1 to each affected employee. And then if there's a lawsuit under WARN, the court may allow the prevailing party reasonable attorney fees, and a state's mini WARN Act may add additional costs. With respect to wage and hour, the final paycheck is owed and sometimes very quickly after termination, and possibly all accrued PTO under state law and or your company's policies or practices. And there's the potential cost of severance in exchange for a release, perhaps because you decided to offer one or because the employee's employment agreement requires it or otherwise. And in terms of unemployment benefits, one perk, so to speak, of this current crisis is that it has been determined that state agencies may not allocate charges to your unemployment insurance accounts for individuals who are paid benefits for reasons related to COVID-19. As discussed earlier, though, employers still must be on top of any state-specific requirements. Now, moving on to furloughs, which is one type of workforce modification strategy we are seeing. It is important to keep in mind that furloughs and temporary layoffs are not the same thing. With temporary layoffs, the employer is terminating the employment, possibly giving the employee a release and severance and saying, we may bring you back later. With furloughs, on the other hand, the employee is not working, perhaps not working for some period of time, or perhaps working 1 week on, 1 week off, but there's generally not a termination of the employment relationship. Now, there are some exceptions. A rare exception is if the employees are off work for more than 30 days in California, that's a presumptive termination. WARN is generally not triggered, but there's an exception. Again, if the furlough lasts more than 6 months or becomes indefinite, now we have an employment loss under WARN. And unemployment eligibility. The employees very well may be eligible for unemployment, and as discussed earlier, they can file, or if you're a Georgia employer, you should be filing on their behalf in any week of the furlough in which they have no work or less work because you've reduced days or reduced hours. Scott, would you like to jump in for a moment to discuss the employee benefits issues with furloughs?
Yeah, just a few things to highlight here from the employee benefit side. So again, I'll sound like a broken record, but your plan document will control what happens if somebody goes out on furlough. But most likely, you're going to have an active at work exception in your benefit plans, which will say that, for example, health insurance will end at the end of the month in which the employee separates from service or is no longer actively at work. And for purposes of a furlough, most insurance carriers take the position that if you're not actually performing any services to the company, you're not getting paid for it, because you're not actively at work. And there's not going to be a hard and fast rule of when you're no longer actively at work. So what a lot of carriers are doing is they are waiving any active at work requirements related to coronavirus right now. But you have to go and you have to ask for an exception or an extension to the active at work requirement. You want to do that for a couple of reasons. One, just to get predictability. You don't want an insurance carrier to deny claims to someone who you have represented. We're going to offer you insurance during a furlough. So if you did not want to provide insurance during a furlough, then the default under your plan would most likely be to terminate that employee's coverage at the end of the month. If you did want to provide insurance, if you go get that exception, most carriers are waiving the active at work exceptions for 90 days. I want to make sure that everybody's aware that that requirement, and that you actually have to go get affirmative consent. If you don't, and you're representing that you're offering insurance to employees and the insurance company denies the claim, there's a potential for the employer to be on the hook to fund that claim if, for example, someone goes to the doctor thinking that they had full insurance during the time they were on furlough. If benefits do terminate, then of course COBRA will be required. If benefits do not terminate, it's not a COBRA event. So you have to wait till the insurance actually turns off before COBRA is triggered. One issue that our clients are struggling with is if benefits do terminate or continue on during furlough and they don't terminate, then how are people going to pay for this? So a couple ways you can do this. You can have the employees pay as they go, so they can actually write checks to the company each week or twice a month or once a month for the insurance costs so that they stay current with premiums. Or more commonly, the employer will front the costs for the employees and then recoup it when the employees come back. Check your plan document, because your plan document might say which one you have to do. You can amend that or change your procedure at any time. If you do the catch-up later approach, you want to put that in writing to the employee so that they authorize you to double up on deductions when they come back, because essentially you're going to take double deductions for that employee's health insurance until they get current again. And to do that under a lot of state payroll rules, you'll have to get employee consent before you can double up on deductions. So the best practice there is to put that in writing and have the employee acknowledge that the employer is going to be paying it for them, and when they return, they'll have to pay it back through additional payroll deductions. Just really quick, just to contrast this for a reduction in hours. So for purposes of furlough, we have the active at work requirement. If it's just a reduction in hours but the employee is still performing services, you can get into a similar issue if the employee is not working on a full-time basis anymore and your insurance plans say you have to be a full-time employee to participate in benefits. There, you'll also need to get an exception from the insurance carrier if you want to extend coverage to those employees after they're no longer technically eligible. One of the things to mention is if you are over 50 employees and you are a applicable large employer under the Affordable Care Act, you'll want to make sure that you're following your measurement period rules. So you might have employees who need to be treated as full-time employees for a full stability period, usually a full 12-month period after you've measured them for 12 months to determine that they are full-time employees. You'll need to make sure that you're honoring that stability period if someone is just working on a reduced schedule. So you might have an obligation to treat them as a full-time employee through the Affordable Care Act, even though they're not technically eligible for the plan. Again, in that case, you'd want to go to the insurance carrier and just say, hey, we've got employees who are working on a reduced schedule for a couple of weeks due to coronavirus reasons, and we're going to keep them on the plan. From every carrier that I've talked to, this has not been an issue, and they've been able to keep employees on their plans through at least 60, 90 days until these issues are somewhat resolved.
Great, thanks, Scott. That's very helpful. As for other considerations to keep in mind with furloughs, they may offer flexible options. So for example, you can have your employees doing all sorts of creative things, working on 1 week on, 1 week off, 2 weeks on, 2 weeks off, not working at all for a certain number of months, subject to what we talked about earlier, how that may not work in a place like California unless you're intending to terminate them. Note that wage and hour issues can arise, though. It's not a perfect solution. We don't have a perfect solution right now in this crisis, but for non-exempt employees, it's important to think about how they're tracking their hours. Are they set up for that at home? What kind of timekeeping system are they using? And is this working for your company right now for these non-exempt employees who are working at home? For your exempt employees, are you paying them their full compensation for any work weeks in which they are performing even a bit of work as they should be getting? And then best practices, they include sending reminders of the timekeeping policies to your employees, updating those policies for remote work, reminding employees that they aren't to do any work while they're on furlough, and reminding managers of the same. We don't want those managers to ask their direct reports just to do a little work here and there on a furlough day or a furlough week. In terms of costs that may arise with furloughs. As noted, there can be a termination of the employment relationship if the furlough lasts more than 6 months or under the certain conditions we talked about in a place like California. Employees also may be eligible for unemployment benefits whether or not the employment relationship is deemed terminated, as we talked about, if the hours are cut, if the days are cut. And if the employment relationship is deemed terminated, there are additional costs such as final pay, payout of PTO if required by state law or company policy or practices, and possibly severance if it's being offered or if it's required. And then in terms of wage and hour, there's a potential for hefty wage and hour claims. So, for example, here's something a non-exempt employee might claim. You know, I was asked to work during a furlough day. My hours were miscalculated, just general off-the-clock issues. An exempt employee might say, hey, I wasn't paid my full compensation in a week. You guys were essentially tying my salary to my hours worked. And Ryan, would you like to discuss how a reduction of hours, furloughs, and layoffs impact retirement plans?
Sure, thanks, Eleanor. So I think when we're looking at reductions in hours, furloughs, or layoffs generally, the question we're getting a lot from our clients is how does this impact our retirement plans, right? And the first issue, I think, and this is the biggest issue we see a lot with compensation generally, is how is the form of compensation that folks are receiving, if they're receiving anything, how is it going to be treated for plan purposes? So, you know, furlough being treated different from a layoff, right? So personal time off being used is, you know, for the most part, under most plans, it's going to be considered plan compensation, whereas severance is not. You also want to think about eligibility and vesting kind of concerns, right? Are you still, are folks still eligible participants under the plan? You know, breaking service rules, if someone is laid off and ultimately rehired in 2020, you're probably not going to have a waiting period for that person when they come back into the plan. And you also want to consider service vesting or crediting service when folks are on layoff and possibly unpaid leave. Generally, they're going to continue to accrue vesting service during that period of time. So just, you know, some things to think about when you're pulling these levers, whether it's a reduction in hours, furlough, or a layoff. Testing, non-discrimination testing is important, right? We're seeing a lot of employees and clients mentioning that employees are reducing or eliminating their employee deferrals under their 401k plan or their retirement plan. If that's the case, they're probably going to have some different non-discrimination testing results for 2020, and you might have some corrections that need to be made. So I think that most employers are anticipating that the ADP will end up being a little bit different in 2020 because of some of these changes. And the last issue is the possibility of a partial termination. Scott mentioned this earlier, but for the most part, a partial termination is deemed to occur if 20% of a workforce involuntarily is terminated within a single plan year. And it's important to think of that as over a plan year, right? If this isn't a photograph or a snapshot during a specific period of time. So if you have a series of layoffs or a series of involuntary departures, then you might need to aggregate those for purposes of determining whether a partial termination has occurred. And remember, the key there is that if you have a partial termination, you'd have to have vesting of the account balances of everyone that was impacted by the partial termination, i.e. the folks that were involuntarily terminated. Eleanor, that's it on the furlough piece on retirement plans. I'm going to kick it back to you for some other discussion on hours.
Thanks, Ryan. So in terms of hours reductions, another workforce modification strategy we're seeing a fair bit of, here are some traps to be aware of. First, is it even permitted? You may see if you have a unionized workforce, it's very important to check the collective bargaining agreements. And then otherwise to check offer letters, employment contracts to see if you can even do this in the first place. Next, it could impact employees' benefits eligibility. So consult with the applicable plans. And then beware of WARN. An employee counts toward the WARN threshold if his or her hours go below 50% in each month of any 6-month period. And then there's potential wage and hour issues. So for exempt employees, as we discussed with furloughs, compensation should not be reduced for any work week in which any work is performed by an exempt employee. So an hours reduction should not reduce salary. There may be state-specific requirements regarding advance notice of reduction if you are doing this along with a compensation reduction, say for a non-exempt employee. So, South Carolina says you must provide an employee 7 days notice in writing of any 7 days notice in advance of any wage reduction. Of course, providing advance notice is easier said than done in these times when personnel decisions may have to be done on the fly, but to the extent you can coordinate with counsel, fewer surprises there will be. And then in terms of unemployment, the employee may be eligible for benefits. This would be a partial claim. And as we discussed earlier, the employee may exceed the fixed weekly maximum benefit, but the claim still may be filed, and in some states must be filed by the employer. If you're not sure, it's best to just go ahead and file. What doesn't hurt, and then you don't get stuck with the potential penalties. And in terms of costs for reduction in hours, WARN may come into play, as we discussed, federal WARN and what it provides. I won't read it again because we talked about it in the prior discussion. And then wage and hour, the potential for expensive wage and hour violation claims for underpayment of full salaries to exempt employees. And unemployment benefits may also be a cost. As we just discussed, this would be a partial claim. The employee may be eligible and he or she may exceed the weekly fixed maximum benefit, but the claim still may be filed, and in some states must be filed by the employer. And now I'd like to turn things over to my colleague, Ryan Gorman, who is going to discuss cost savings with you.
Thanks, Eleanor. So this kind of goes back to the first question we started off with. A lot of employers are asking how they're going to pay for this. So, but working on, we see a lot of employers considering suspending or reducing or delaying compensation, and I think that's important to consider that aspect. And we see it's actually pretty common. But if any amount is accruing and being paid at a later date, what is really important there is to be mindful of Code Section 409A, which can have pretty nasty tax consequences on the employee. So paying any kind of foregone salary, there are ways to do it to avoid 409A issues. They could be either 409A compliant or exempt. The first is to pay through a formal non-qualified deferred compensation plan. That's probably not common or not likely in this instance. In these kind of scenarios, you're going to have employees, that structure is more designed for long-term deferrals. What is more common is you're seeing employees, folks deciding to pay later this year, in 2020 or by March 15th of 2021. If you do that, you're generally going to be exempt from 409A and not have any kind of deferred tax consequences or deferred compensation consequences. There's also a rule under 409A that allows folks to delay compensation if the payment of the compensation would jeopardize the ability of the company to operate as a going concern. Generally, that has limited application and is a high standard, but these are unprecedented times. So we do think that some employers are able to rely on that if they're going to delay compensation and ultimately pay at a later date. If you do it in accordance with that kind of rule, it could be fine from a tax perspective. And then we also see folks putting together transaction bonuses, generally subject to continued employment through that date. Another way to possibly avoid any kind of 409A concerns is if somebody has delayed compensation, but they're going to pay it and it's been an accrued amount. If you can delay it and the employee has to be employed on the date of payment, then it's generally not going to be an issue and it can be exempt from 409A. The same way the same kind of outcome would apply if the employer had discretion to pay the amount entirely. Not the timing, but whether or not to pay the amount was retained by the employer. So those are issues or ways you can kind of generally structure this in these issues to avoid any kind of nasty outcome from 409A perspective. Generally, some things to avoid with reducing employee pay. Any kind of employee or company discretion on timing of payment. We'll pay you when we decide to kind of issues. You also want to avoid accruing the foregone amount on the employer's financials without papering the obligation. And always consider updating the employment agreements and offer letters to the extent that those salary numbers, which might be outdated now, are being updated when you're making these changes. So the next item where we're seeing folks, potentially maximize or try to get some kind of savings and try to bridge the gap here during this difficult time is what I have here on slide 25, suspending or reducing employer contributions. So this is a pretty good saving opportunity that a lot of employers are using. Think about the amount of an employer match or an employer non-elective contribution under a retirement plan, profit sharing contributions, and things to that effect. Those could be amended during plan years under certain circumstances. The first rule applies to all plans, and if participants have to be given the contributions they've earned prior to the amendment. So you have to give them what they've earned. But after, if an employer decides to reduce or suspend their contributions to their retirement plan, you want to look to whether the plan is a safe harbor plan or a non-safe harbor plan. For the most part, non-safe harbor plans have plenty of flexibility, right? These are plans where, generally we do recommend corporate action, a board consent or a committee consent or some kind of action to say, hey, we're suspending or we're reducing our employer contributions, but that's kind of all you have to do there. With safe harbor plans, there's a little bit more red tape involved. So you want to first look to, if an employer decides they want to reduce their employer contribution, you first want to look to the safe harbor notice and see, did the company reserve the right to reduce that contribution source or contribution amount? If they didn't, the only way you can reduce during the middle of a plan year is if the employer is operating at an economic loss. Now, that standard, like in many ways, like the 409A standard I mentioned earlier, those historically are harder to meet, but it might be more common for companies to say they're operating at an economic loss. In any event, if one of those two requirements is satisfied, the safe harbor notice, reserve the right, or you're operating at an economic loss, you can amend a safe harbor plan mid-year, provided you give 30-day advance notice to participants, and the ADP, ACP, and top-heavy testing, that's going to have to be performed, right? You're not a safe harbor plan. Anytime you make any modification to what's in the safe harbor notice, you are going to have to perform that testing. So, just things to consider when employers are, working through those kind of cost-saving opportunities to kind of bridge the gap here. And as we move forward here, I wanted to have Eleanor speak to this workforce modification charts. Well, labor employment attorneys love their charts, right, Eleanor? So I figured you wanted to give us a little context about this chart you put together to kind of summarize what we've discussed so far.
Thanks, Ryan. We do love our charts. We just put together this chart that shows some considerations for different topics. As you see on the top, the topics, and then on the left, the types of workforce modifications that employers may be making, and then it shows some pros and cons, the pluses and minuses. So we're hoping this might be a useful one-pager that you can take away from this webinar, and we will be making the slides available to you all if you didn't know that already after the presentation, so you can look back. Thanks. Thanks, Ryan.
Sorry, I was talking to myself on mute there for a second. Moving on to CARES Act and retirement plan provisions, and we're getting a lot of questions about this. Generally, obviously there's a lot in the CARES Act, but there's a lot specifically devoted to retirement plans. So generally, I think these are pretty well-designed features, right? So we have these provisions impact qualified individuals, and qualified individuals are it's kind of it's a difficult concept to determine who is a qualified individual. So here's the standard generally. It's a participant who is diagnosed, a participant or a spouse who's diagnosed with COVID-19 by a CDC approved test, or as a result of COVID-19, they experience an adverse financial consequence due to being quarantined, furloughed, laid off, having their hours reduced, or being unable to work due to lack of childcare, or closing or reducing of operation of a business owned or operated by the participant. You know, thinking about that in the abstract, that seems like that's broad, but, you know, it can be difficult to apply this. I mean, think about an example of if someone had a spouse that lost a job. It could be that they are not a qualified individual for some of the relief that I'm about to discuss in a few minutes for retirement plan purposes. So luckily, under the CARES Act, employers can rely on self-certification, right? So it allows self-certification. Employees are allowed to say, I am a qualified individual. But we think it's important for plan sponsors to keep records of certification with their plan files and plan records. So, you know, record keepers are doing this in a couple of ways. They're having audio recordings of the person saying on a recording saying, I am a qualified individual after possibly the requirements are listed. Or you see employers and record keepers saving copies of signed attestations saying, I am a qualified individual. Moving on, so what's in the CARES Act? There's a lot in it, but as it relates to retirement plans, there's a couple provisions that are really key. And the first is these coronavirus-related distributions. So this allows for a special withdrawal right. This is only for defined contribution plans. And it's similar to what was done in the last couple of years with hurricane relief. So this allows a special withdrawal right of up to $100,000 that is not subject to the early withdrawal penalty. So that also, these CRDs, they also have the added benefit of folks being allowed to spread the tax outcome or the taxable event to them over a 3-year period, and also allowing folks to repay distributions to the plan during that 3-year period to avoid income recognition altogether. There's also pretty notable relief regarding plan loans for retirement plans. So coronavirus-related loans, this is only for CRDs and CRLs here are only for qualified individuals, and like we mentioned on the previous slide, but it expands the amount of sources in folks' retirement plan accounts or defined contribution plan accounts rather only. To the lesser of $100,000 or 100% of their vested account balance. So that, that's an expansion from the general rule of $50,000 or 50% of vested account balance. So it's a pretty notable expansion of the amount of loans that someone can take out under a plan, and also the CARES Act allows folks to defer loan repayments that otherwise are due in 2020. There's also a waiver of required minimum distributions for defined contribution plans, and this is important. This is for all participants, not just qualified individuals. So this is for folks that would have taken required minimum distributions in 2020, including those who turned 70 and a half in 2019 and haven't taken their first RMD. The rationale here, probably from the congressional perspective, is we don't want to push money out of retirement plans if we're at the bottom of the market or at a low point in the market, and not allow folks to, unless they actually need it, to allow folks the opportunity to get some of their savings back if and when the market does bounce back. A couple other questions about the CARES Act that we're getting a lot. Are these changes mandatory? Do we have to, right? We're getting that question a lot. Are other clients, what are we seeing in terms of other clients adopting the changes? And the answer is that all these provisions that I described are not mandatory. They're optional, right? But we think that most employers, in our experience, are offering them to the maximum extent allowed under the law. And I think that's for a couple of reasons. The first part is the prevalence and awareness of these provisions. I think these are the ones that are grabbing headlines in the newspapers or on CNN, right, where people are able to listen to the news and hear that, oh, I read about this. I'm surprised my employer's not offering this. And it's also difficult for an employer to know if their employees are impacted. Even if you don't have layoffs or reductions, it could be that employers that your employees are needing these funds one way or another. So it's hard to kind of determine this, without saying on a across the board basis, oh, it doesn't apply to me or it doesn't apply to my workforce. There is an argument that the RMD suspension is mandatory, but we don't think that's the right interpretation. And in fact, we're seeing vendors properly allowing participants to opt out of that suspension. So it's not that you have to do a suspension of required minimum distributions from plans. You can allow folks to opt out of that process. Any reason why we shouldn't offer them? We're getting that question quite a bit as well. And two possibilities there, or two arguments about why you wouldn't. The first is plan leakage. There's a lost earnings opportunity if and when there is a market bounce back. These distributions that are going to be made, particularly the CRDs, the distributions up to $100,000, they're not likely to make it back into the plan ever, right? So this is money that, other than plan loans, which might be repaid to the plan, they're not likely to make it back into the plan. So it's going to potentially lower the retirement readiness of your population. The other item of, the other why not would probably be the administrative burden. I think employers are seeing an uptick in distribution requests generally, so or loan requests, and adding this to that process would probably only complicate matters. But for the most part, I think that's a third-party record keeper concern, not necessarily an employer concern. So when we look at the whole picture, we take a step back. I think, for the most part, since it's really hard for employers to know when their participants are going to need these changes, our recommendation is that retirement readiness and administrative burden aren't really items that should preclude you from offering these, and that for the most part, we think it's a great offering to offer to your participants as long as you're prepared to administratively handle it. And the last question we get from time to time is, can we wait to implement these provisions? And the answer is yes. They could have been made effective as soon as March 27th, which is when the president signed this into law. But you can wait until it makes sense for your workforce if you think that you need to kind of wait and see if there are gonna be questions about it, or if you're not implementing some kind of workforce changes yet, or don't plan to. Maybe you kind of cross that bridge when you get to it. The one thing in terms of papering this whole thing is plan amendments can be delayed until 2022. So you can take advantage of it now and just kind of brush it up from a legal plan document perspective at a later date. The last slide, I'll touch on this briefly, is because of the tax return deadline for 2019 being extended to July 15th from April 15th. There are some deadlines that have been extended for benefit plan purposes. So the deadline for reporting and paying early withdrawal penalties for 2019 distributions has been delayed to July 15th, as has the deadline for HSA contributions and employer contribution deadlines for 2019 plan year contributions. One important exception to this is the April 15th deadline, which is tomorrow, to distribute excess elected deferrals over the 402G limit. That was not delayed. So it's important that employers do push that money out. Otherwise, we're going to have you'll have an instance where folks are potentially subject to double taxation in the year of deferral, or in the year of the initial deferral and the year of distribution. So something to keep in mind as you go through and plan for some of your deadlines and timelines for operating your plan. So with that, I'm going to turn it over to my colleague, Abby Larimer. She's going to touch base on some of these stay-at-home orders and the questions we're getting about that. Abby?
Thanks so much, Ryan. Yes, we've been getting a lot of questions about stay-at-home orders and shelter in place and what it means to be an essential business. So one question we've seen a lot of is, I'm currently under a shelter in place or stay-at-home order. Does this mean my business has to shut down? And, of course, one of the favorite lawyer answers is, it depends. If you've looked at these orders, you'll see that there's a lot of variance between them and how they're written. And what is considered an essential business is determined at the state and local level. but many states are also looking at the essential critical infrastructure guidelines that are provided by the United States Department of Homeland Security. Generally, essential businesses are ones that include healthcare, doctor's office, even vets, nursing homes, infrastructure like airports and airlines, public water, wastewater, manufacturing, retail and grocery stores, like even farmers markets, pharmacies, gas stations, other services like trash and recycling collection, mail and shipping, laundromats, child care, auto repair, news media, financial institutions, other providers of basic necessity, construction, defense, and other any generally services that are necessary to maintain safety, sanitation, and other essential operations of residents or other essential businesses. So what if I should be essential? If you've reviewed the applicable order that you're under, can you do anything if you think that you should be considered an essential business, but you're not yet on the list? There's still not a lot of guidance on this, but we're expecting some more information to be forthcoming, as with everything else. Some states like Pennsylvania, New York, and Connecticut have allowed businesses to apply for relief online. And so as an example of this, the governor of Pennsylvania expanded this list to include sectors of natural resource and mining industry, dry cleaning, insurance carriers and agencies, and other accounting and tax preparation services. We've also seen some companies in other jurisdictions file for injunctive relief with the court, asking for a court to declare them an essential business so that they can keep operating. So if you've reviewed the applicable order and you're a non-essential business, what do you need to do? So some things to think about: setting up your workforce remotely. What is that going to entail? Do you need to do employees need additional supplies like laptops, increase of a network capability, or additional access to more VPN connections? You also want to make sure that your employees have resources to any documents, records, or other resources when they're away from the office. And additionally, what goes along with that is determining how you can secure your facilities, including the business's confidential information, and maintaining your property. And also want to determine whether you need an emergency telecommuting policy. One thing to think about here too is whether employees need to be reimbursed for specific business expenses that they incur when they're working from home. Some states require this, like California. And also consider how non-exempt employees are going to be recording their time worked when they are working remotely. Can you be penalized if you violate a shelter-in-place or stay-at-home order? That's also something that's going to vary from state to state and in jurisdiction, but yes, and penalties can include various citations, fines, suspension of certain licenses, your business license, and even criminal penalties. So you'll just want to pay attention to what's in place where your business is located. So another question we're seeing a lot of: what about paid sick leave? My employees are subject to a shelter-in-place or stay-at-home order. Does this mean that they're going to qualify for emergency paid sick leave under the new regulations? And again, it depends. According to the guidance issued by the Department of Labor, the key question here is whether the employee is going to be able to work or telework, but for being required to comply with any sort of quarantine, isolation, containment, shelter-in-place, or stay-at-home order. So the example provided by the Department of Labor is a coffee shop that would close down temporarily or indefinitely due to a downturn in business related to COVID-19. An employee here that's subject to a shelter-in-place order is not going to be eligible for emergency paid sick leave because the inability to work isn't tied to the need to comply with the order, but rather closure of the place of employment. And this can be true even if the closure of the business is directly related to such an order. So like the order stopped force the coffee shop to close, or there's some indirect relation to the order, like the coffee shop is closed because the employees or customers are being required to stay home. And in both of those situations, the reason that the employee is unable to work is not because the customers, it's because the customers are subject to the order, not necessarily the employee. So therefore, they're not going to be eligible for emergency paid sick leave. Another question we've received: if I am subject to a shelter in place or stay at home order, can I proceed with laying off employees either temporarily or permanently? Generally, the answer here is going to be yes, but you also want to consider whether these actions will trigger any WARN Act protections or other equivalent state acts. And one other note, the Department of Labor is recognizing that right now, with people working at home, there are some adjustments that are going to have to be made to wage and hour rules. So the Department of Labor has temporarily suspended the continuous workday rule, which is for employees working from home as a result of COVID-19. This means employers who are allowing non-exempt employees to work from home and break their day into chunks of working time, understanding that you may have to take care of some personal business in between, do not need to treat the entire day as compensable under the Fair Labor Standards Act as they normally would. So here's the example of someone who is working 7 to 9 a.m. And again, we're talking about a non-exempt employee here, and then maybe 12:30 to 3 and 7 to 9. The employer does not need to pay for the entire 7.5 hours that were actually only for the 7.5 hours that were actually worked, and not the 14 hours between 7 and 9 p.m. And if that individual is interrupted to take care for a child, maybe they give the example at 8:30 p.m. and it comes back to work for a half hour at the end of the day, the employee is still going to be paid for that time that was actually worked. So now I think we've got a little bit of time left, so I think we'd like to talk about some questions. So I see that we've been trying to answer some of these as we'll go along, but I will turn it over to, I'm not seeing any about the essential leave provision, so I'll turn it over to my colleagues if they have some questions that they see that they would like to answer right now.
Sure. This is Meredith. I've tried to answer several of the questions in the Q&A about the FFCRA. There is one question from Michael that I think is about the FFCRA. It's about the distinction between being laid off versus reduced hours and what people are eligible and what they can use under the FFCRA. So I'll spend a couple more minutes trying to kind of clarify that because it is a little bit confusing. The basic idea is if you have laid people off, which means you have terminated their employment, they no longer work for you, they're no longer receiving benefits, et cetera, then you're not they're not eligible for anything under the FFCRA. You're not obligated to provide them with anything under that law. If you have employees, on the other hand, who are on what's called a furlough, which means they still work from you, you have just reduced their hours, either completely, you've told them don't work for a while, or you have reduced their schedule, reduced their hours by a certain amount of time. If they are still your employee, then they are eligible for the FFCRA. And the amount of time that they are eligible for depends on what their work schedule was before you made the COVID-19 reduction. So if you have a full-time employee that you put on a furlough, if they are still your employee, they are entitled to the same amount of time that they would otherwise be entitled to based on a full-time schedule. Same thing with part-time people. If you've changed a part-time schedule, they're eligible, they sort of have in their bank an amount of time based on their part-time schedule prior to the time you made the reduction. But the caveat is, even though they sort of have that time in their bank, they can't actually use it if you haven't scheduled time for them to work. So yes, they may be eligible and they may have a bank of, 80 hours of paid sick leave, but if you put them on a furlough and they don't have any hours scheduled to work, they can't use it until you schedule them back again. So basically they would hold on to that time, and then if things start ramping back up, if it's prior to the end date of the FFCRA and you put them back on the schedule, they could conceivably take that time if they have a qualifying reason down the road. Hopefully that was helpful and answered the question properly.
One sort of administrative question that we've received a few times is whether the slides and the recording will be available, and both will be available. You should receive a link for the slides as a PDF, and then the webinar will be posted on our website shortly.
I'm not sure if anybody else wants to jump in.
Yeah.
Sorry, Ryan,
I'll
go
answer
ahead.
one question. Yeah, one question that was asked about amending a safe harbor plan mid-year to reduce compensation or contributions from the employer side. And the question was, does it matter if the company has historically been operating at a loss? And recall that, you know, one of the ways you can amend a safe harbor plan during the middle of the plan year and reduce those contribution sources would be if the company's operating at an economic loss. And the key is that there's an economic loss from the employer's perspective during the plan year, and there's it's a statutory definition. So it's that the employer, it's facts and circumstances obviously, but it's that the employer is operating at an economic loss, that there's substantial unemployment or underemployment in the trade or business in the industry concerned, sales and profits of the industry are depressed and declining, and it's reasonable that the plan will only be continued if the waiver is granted. I don't think it's as far as that, but there is some guidance and some statutory guardrails that kind of give us context about what an economic loss is. But it really just looks to the plan year that's in which you're making the suspension or change itself, not necessarily the historical operation of the business.
Somebody has asked a question about, do we need to update our handbook to include the paid sick leave and expanded family medical leave information? That is definitely very recommended. Not everybody is doing that, but certainly it's a very good idea, just so there aren't any questions. It's very easy to plug in something about the expanded FMLA into a handbook, and then, the paid sick leave is a kind of a 1 or 2 page document. So it's very easy to do that, and we do recommend it.
There's also a question that I sort of answered in the Q&A about whether or not you can ask for a doctor's note if you think that an employee is cheating the system with respect to FFCRA leave. We've gotten some contradictory guidance on this. The regulations do say that an employer cannot request any documentation from an employee other than what the regulations say that you can provide, which is essentially, the name of the employee. The employee has to state the reason that they want to take the leave, the circumstances surrounding it, and then if it's one of the qualifying reasons that implicates, for example, a quarantine or isolation order, you have to provide some information about the order. If it implicates a school closure, you have to provide some information about the school closure. And if it's an order, for instance, a quarantine order from a doctor, you have to provide information about the doctor. There is nothing in there that would allow you to request a doctor's note for the FFCRA leave. In particular, the one qualifying reason that you're probably concerned about, which is the one where someone is actually experiencing symptoms and seeking a medical diagnosis, there's nothing specific in terms of documentation tied to that qualifying reason other than the employee saying that that's the qualifying reason. So, the safest, most conservative thing to do is to follow that part of the DOL's instruction and not require anything else. However, there's been some additional authority that indicates that employers can still require employees to comply with their normal policies for taking paid sick leave or taking leave. Those notice requirements, doctor's note requirements, and especially if they're taking the time for themselves and their own sickness and they would, otherwise be entitled to regular FMLA, there's some indication that you could have them follow the normal FMLA certification procedures. Just based on the contradictory information, this is kind of a fraught area. So we'd suggest if this situation arises, reach out to counsel and discuss the particular facts, because it you know, the advice would probably depend a lot on what the situation is, what's going on with the employee, and sort of other factors, because you, I think, want to err on the side of not requiring employees to potentially overburden an already burdened medical system by getting additional documentation that arguably the statute doesn't require.
Okay, I think that about wraps it up. Thank you, everyone. We appreciate you spending this time with us. We'll be sending a follow-up email with information on continuing education credits, a recording of today's webinar, and the contact info for our presenters. So please be sure to reach out with any questions you may have on this or any other topic. Have a good day.